To make the best use of the session, I suggest you do two things. Number one, go through my theory session on legal reasoning. The link to the session is given on the description below. Second, create a free sign-up account on our website and solve the exercise on your own before you go through the video. The process for the free sign-up is also given on the description below. Now that you would have done both the things, let's start the class. Hello students, welcome to another class on practice of legal reasoning questions, old pattern. Those who are doing this class for the first time, you may visit the theory class and also my first and second class on practice. Okay, so we'll be practicing 8 questions today. The way to practice this would be, if you have already not attempted this exercise on our portal, do that. If somehow you don't want to do that, pause, attempt, and then play the video. This is the first question on your screen. Okay, so the insurer agrees to pay no more than the actual amount of loss. So whatever the amount of loss, the insurance will not pay more than that, can pay less than that or equal to that, but not more than that. Okay, now look at the fact situation. Insures his cars worth rupees 5 lakh for its value. So this is the value. We can safely infer that this is the value of the car, 5 lakhs. He again insures the same car with Y, another insurance company, on the same terms. There is an accident and the car suffers a total loss. Total loss means 5 lakh ka loss. So what is the max an insurance company will pay? 5 lakhs. In a separate suit against X and Y, if Sunny recovers rupees 5 lakhs from X, so it's already recovered 5 lakhs from this insurance company X. So now what is his loss? 0. His loss is 0. How much can he recover from Y? Now he can recover 0, right, from Y, because he has already got the total amount of his loss, which is 5 lakhs. And therefore the answer is B. Sunny cannot recover any amount from Y. You might think that he can recover 5 lakhs because that is a loss. Once he recovers that amount from X, his loss is 0 because he has recovered the complete loss amount. Okay, let's go to question number 2. Pause, solve, play. When there is an infringement of the legal right of a person, he gets a right to sue the wrongdoer for remedy. This is the key word. Irrespective of any actual loss caused. तो उसको loss हुआ कि नहीं, that is not important. If a legal right is violated, he can sue the person. Okay. Now Saroj is prevented from voting at an election. So this is the legal right of Saroj to vote. So that is violated. So Saroj can sue now. As simple as that. The candidate she intended to vote for wins the election. So now you might think there is no loss. She wanted to cast a vote in favor of some candidate. The candidate won. So loss ही नहीं हुआ है. तो कुछ sue नहीं कर सकती. No, but the principle says irrespective of the loss. Her right is violated. Yes. Second thing is unimportant. Okay. Saroj's legal right has been violated and she can sue the person who prevented her from voting. This is the correct answer. Since Saroj's candidate has won the election, her rights are not violated. No. Basically, this is saying since there is no damage, no loss, she cannot sue. No. It's not the candidate. Again, this is outside the scope completely. And again, this is not the answer. The correct answer is A. Let's go to the next question. Cannot be sold to consumers after its date of expiry, which means it could be sold on the date of its expiry, but not after its date of expiry. Okay. Lata, while shopping, notices that the milk packets on the shelves are due for expiry on that day. She objects to this to the shopkeeper, saying that since she was there to buy milk for the next day, keeping the milk on its date of expiry was against the law. Right? Against the law would be if the next day she is planning to sell it, right? Not on the day. So it is not against the law. Let's look at the choices. Lata is right and the shopkeeper should take the milk packets off his shelves. No. The shopkeeper should not sell the milk packets after the date of expiry is over. That is what the principle says. I'll keep it for a while. The shopkeeper must remove the milk packets from the shelves and keep it refrigerated. Again, it's outside the scope of the principle. And milk is not a product, and hence the principle is not applicable. This is out. So this is the correct answer. Third, the correct answer is B. Let's do question number 4. Nuisance is the unlawful interference with a person's enjoyment of his land or some rights over or his connection with it. Unlawful interference with a person's enjoyment of his land or some rights over or in connection with it. Okay. Ashok in his 90s is hard of hearing and plays the radio very loudly throughout the day and on a daily basis. Very loudly is the keyword here. Raju, his neighbor, complains that he cannot listen to his favorite TV show in his home due to the radio of Ashok. So, do you think this guy Raju has a right to enjoy his home and the TV which is in his home? Yes, he has the right, which is being violated by Ashok. Listening to radio is Ashok's freedom, yes, but not interfering with the right of his neighbor. That is not his right. Ashok is creating nuisance to his neighbor by playing the radio loud perpetually and disturbing Raju in being able to listen. Yes, this is correct. I'll keep it for a while. Let me check the other options. Raju is creating, no, it's not creating nuisance. He's just asking for his right. Raju should appreciate, again, beyond the scope of the principle. The correct answer is B. Agreement in restraint of trade are void and unenforceable. Restraint of trade means which stops you from doing a particular trade, any trade. So if I am teaching and if someone comes and enters into an agreement that Abhishek, you can't teach anymore, now that is void and unenforceable because that is restraining me from doing a trade. Okay. Manu has been working as a blacksmith in his village for many decades. Somu has been undergoing training with him for the past 3 years. After his training is over, Somu enters into an agreement with Manu that he will not start a competing business in the same village. All you have to figure out or decide is whether this is in restraint of trade, yes or no. This is yes in restraint of trade. Therefore, it would be void and unenforceable. Let's look at the choices. This agreement is void and unenforceable since it is restraint of trade. Yes. Such a good question. Pehle choice mein answer de diya, right? So you may check, you may want to check the other choices, but this is the best answer. The agreement is valid, no, outside the scope, because he is Somu's teacher, no. The agreement is valid, but not enforceable after, no, beyond the scope of the principle. The agreement is valid and enforceable, no, this is not. Anything in restraint of trade is void and unenforceable. Do not use your external knowledge of law, restrict to what the principle says. Number 6. A characteristic feature of partnership is the principle of mutual agency. That is, every partner is an agent for every other partner and will hence be able to bind them by his act with the business, within the business of a partnership. So basically, if you are doing something which is a part of the business of the partnership, the other person, you bind that person. So agar main aur aap partner hain aur main padha raha hu, and somehow if I let's say buy some account, some online account to increase my bandwidth, right? So that is binding on you also. That is binding on the firm to pay for this account because मैंने अपनी company के business के लिए करा है. लेकिन if I take an account for my personal use, in which I chat with my friends, उसके लिए partnership firm is not liable. This is what it says. Mutual agency and within the business. Let's look at this. Ram and Shyam are partners of MS trading company which trade in rice varieties. Okay. Ram agrees to purchase 10 tons of rice from Govind, fine, for the business. Ram dies after the rice is delivered to the premises of these people, but before the payment. So, first decision, was it doing this for the business of the firm? The answer is yes. So, the mutual agency and the binding would be there. Is the agreement binding on the Shyam? It is, because it was for the business. Being partners, Ram's agreement to purchase rice for the partnership is binding on Shyam. Now, as I said, do not use external knowledge, right? Someone who is a student of accounts might think that, okay, once a partner dies, the partnership is to be dissolved. There's no partnership firm, and maybe then this is not binding. Do not use external knowledge, guys. Restrict yourself to only the principle. The principle does not mention anything before that, after that. So, usko use ही नहीं करना है. ठीक है? Number 7. One of the principles of natural justice states that no person shall be liable in his own cause. In his own cause means where he has certain stakes. ठीक है, मेरा कुछ ना कुछ इसमें involvement है, तो मैं उसमें नहीं कर सकता. Let's say husband wife, let's say a teacher student, you may say have a personal stake, you have your own cause, so usme you cannot be the own judge, right? So agar let's say kisi corporate mein, if there's a sexual harassment case और जिसके against harassment है, as per this principle, that person cannot be the judge, cannot be a part of that committee. Okay, now let's look at this. A driver of B. So between A and B, is there a natural cause or own cause? Would there be an own cause? Yes, because employment hai. Okay. A driver of B, a branch manager of ABC company was caught suspecting theft in the bank premises. The bank manager instituted an inquiry and made B the inquiry officer. Now B is the employer of A. There is an own cause. So as per the principle, he should not be made the judge. As B is a bank manager and not a judge, this principle is applicable, not applies to the principle here. Since the theft was in a bank premise, the manager is the only competent person, not applicable. Since B is the employer of A, B should not be conducting, yes. Always the principle which is given has to be implied. A, B में वो apply नहीं हो रहा है, C में apply हो रहा है. The principle will be applicable only the theft committed by A was in no, does not apply. Because B is the employer of A, there's an own cause, cannot be made the judge. Last question of the day. Pause, solve, play. A person who keeps hazardous substances in his premises is responsible for the fault if that substance escapes in any manner. This is important. In any manner, whether it's your fault, someone else's fault, in any manner means kuch bhi cause ho. Now, those who know law, they might apply strict liability here, but uska exception hota hai. Yahan pe that doesn't apply because the principle categorically says substance escapes in any manner. It might be due to the mistake, right, or negligence of the person who faces damage, but wo yahan pe nahi aayega. It says in any manner. Okay. A, an industrialist, stores 1,000 liters of liquid ammonia in a tank in his premises for his industrial use. There was a leakage from the tank due to which there was ammonia vapor in the surroundings. So leakage ho gaya. So your responsibility. Many workers in other industries as well as his own industry and some members from the public suffered health hazards. He is responsible, right? Responsible for the fault because of the leakage. As this is a simple question. A may be liable for the injuries sustained by his workers and not for others. No. A is liable as a responsible for the injury caused by the leakage. This goes with the principle. I'll keep it for a while. A is not liable. Liable to hai. See, first of all, you have to decide liable or not liable. So he is liable. So option number C and D are out. Now, when he is liable, you have to look at the other part of it, the explanation part. B is a better answer. So this is the correct answer. So yes, guys, we would be doing lots of questions here. Lots of content, relevant content would be covered here. I've been training students for various examinations. The common thing which helps people to clear the exam is the number of mock tests that they write. So writing sufficient number of mock tests is extremely important, and also those mocks which come very close to the actual paper. We have invested a lot of time, energy in coming up with a test series which comes very close to the actual CLAT paper, right? So if you are a serious CLAT student, you have to prepare with our test series. We have given you the opportunity to create a free sign-up account with us, test the quality of our content, and then start preparing with us. Remember, coaching kahin se bhi, but test series has to be from Mentors Capital. All the best. Take care.